Protection in respect of conviction of offences. Article 20, 21, and 22 provide a system for protection relevant to criminal law. Article 20 guarantees to all persons, whether citizens or non citizens, three rights, namely protection against ex post facto laws. According to Article 20, no person shall be convicted of an offence except for violation of a law in force at the time of the commission of the act charged as an offence, nor be subjected to a penalty greater than which might have been inflicted under the law in force at the time of commission of that offence. Ex post facto laws are laws which punished what had been lawful when done. If a particular act was not an offense according to the law of the land at the time when the person did that act, then he cannot be convicted under a law which with which with a retrospective declares that act as an offense. For example, what was not an offense in 1972 cannot be declared as an offense under a law made in 1974, giving operation to such law from a back date, say 1972. Even the penalty for commission of an offense cannot be increased with a retrospective effect. For example, suppose for committing dacoity, the penalty in 1970 was 10 years imprisonment and a person commits dacoity in that year. By a law passed after committing the dacoity, the penalty for his act cannot be decreased from 10 to 11 years to life imprisonment. In Shiv Bahadur Singh versus State of Vindhya Pradesh, it was clarified that Article 20 prohibited the conviction under an ex post facto law, and that too the substantive law. This protection is not available with respect to procedural law. Thus, no one has a vested right in procedure. A law which nullifies the rigor of criminal law is not affected by the rule against ex post facto law. Protection against double jeopardy. According to Article 22, no person shall be prosecuted and punished for the same offence more than once. It is, however, to be noted that the conjunction and is used between the words prosecuted and punished, and therefore, if a person has been let off after prosecution without being punished, he can be prosecuted again. Protection against self incrimination. According to Article 23, no person accused of any offence shall be compelled to be witness against himself. In other words, an accused cannot be compelled to state anything which goes against him. But it is to be noted that a person is entitled to this protection only when all three conditions are fulfilled. 1. That he must be accused of an offence, that there must be a compulsion to be a witness, and such compulsion should result in his giving evidence against himself. So, if the person was not an accused when he made a statement, or the statement was not made as a witness, or it was made by him without compulsion and does not result as a statement against himself, then the protection available under this provision does not extend to the person or to such statement. The right against self incrimination protects persons who have been formally accused as well as those who are examined as suspects in criminal cases. It also extends to cover witnesses who apprehend that their answers could expose them to criminal charges in the ongoing investigation, or even in cases other than one being investigated.